We're going to study the applications of fundamental rights with respect to issues. This is important for the mains and the final leg of our theme 3, in which we are going to be studying first the PYQ analysis of all the mains questions that have been asked. And through this, we will understand the three most important fundamental rights 14, 19, and 21, plus directive principles. Plus directive principles. All right? Okay. It is working now. It is working. Mic is working now. So we'll understand 14, 19, and 21 with respect to directive principles. And then we'll start very specifically with Article 19. Under Article 19, we will cover first press rights / rights of journalists. We will cover sedition. We will cover hate speech. And we will cover censorship. In censorship, we would particularly be looking at cinema and OTT platforms. And then OTT platforms. Once we are done with this, we will then look at Article 21. In Article 21, we will cover euthanasia, we will cover privacy, and we will cover LGBTQIA+. Once we are done with this, from a religion point of view, we are going to cover the Uniform Civil Code. Okay? These are some of the primary issues that have to be covered. And then, lastly, and least importantly, we are going to be covering reservation. Okay? These are broadly the 6 areas that we have to go through, or we have to undergo as far as our applications of fundamental rights are concerned. Okay? So let's start with the analysis of previous year questions. You will have them in your drive, and let's quickly look at them, and we'll understand how have these questions been asked, what is the primary basis of these, and so on and so forth. Now please pay attention. The topic that we are referring to, the topic that we are referring to is the very first theme in your mains syllabus. It says Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions, and basic structure. We have already covered basic structure when we discussed uh, Article 368, Article 13, Clause 2. We've already covered, for example, we've already covered the evolution of fundamental rights, the amenability of fundamental rights, and we've also covered the relationship between rights and directive principles. Basic structure and evolution are correlated. Okay. We will look at some of the significant amendments towards the latter end of the course. As far as historical underpinnings are concerned, the only question that is usually asked in here is the impact of the Government of India Act 1935 on the Constitution of India. And for this, I have already given a handout on the drive which you can go through, and I will go through the handout towards the end of today's class. And through features and significant provisions, we are going to be looking at FR issues. Now you will understand that though the syllabus has certain words, a lot of these words are actually never asked per se as far as questions are concerned. Okay? Clear? Alright. So, let's look at some of the questions that have been asked so that we understand exactly what it is that we have to cover. So, in 2013, the question was, discuss Section 66A of the IT Act with reference to its alleged violation of Article 19 of the Constitution. Now, if you notice, the most important word in this question is its alleged violation of Article 19. The most important word is that it is alleged violation of the Constitution. Okay. Now, this means that the Supreme Court has not yet declared or delivered a judgment which says Section 66A is violating the Constitution or violating Article 19. The judgment on Section 66A, which is popularly known as the Sakal case, has not at all been delivered by the Supreme Court. And because the judgment has not been delivered by the Supreme Court, there is a legitimate question which is, do you think this particular law violates a fundamental right? You will always get a question on whether this particular law violates a fundamental right or not on the basis of if the Supreme Court judgment has been delivered or not. If the Supreme Court judgment has not been delivered, then you can get a question on whether a law is violating a right or not. If the judgment has been delivered, then you will always get a question which says, what is the impact of the judgment? So, pre judgment, whether it is a violation or not, post judgment, the impact of that judgment on the violation, right? Now, Article 23, second question in 2013. The Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution and discuss critically. The Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. Discuss critically. This basically is asking you a question on Article 368 and how the Supreme Court has kept a check on the Parliament by restricting the powers under Article 368. If you notice, the question is about whether the powers that have been curtailed are justified or not. Should there be a restriction or not? Which basically means, is the basic structure justified or not? They are not asking you to get into a deeper analysis of the landmark judgments that have come into place. In fact, they are simply asking you whether basic structure, which is restricting the powers of the parliament to amend the constitution, is that basic structure valid or not? From what we have discussed yesterday, you should be able to successfully answer this question under any and all circumstances. Then see question in 2014. Always remember, the longer the question, the easier it is to answer, because the longer the mains question, it is even more clear to the student as to what exactly is the question demanding, what exactly are you supposed to be writing, right? So, this has three parts. What do you understand by the concept of freedom of speech and expression? Does it cover hate speech also? And why do films in India stand on a slightly different plane than other forms of expression? Than other forms of expression, right? Now, 2014 is election year. Whenever there are elections, there are speeches, and speeches can sometimes take the shape of a hate speech. And this is also around the same time where the leadership to the Censor Board of India had undergone a change, and that change was severely criticized by several people in the country, and several members of the Censor Board had also resigned in protest of the new chairperson of the Censor Board, and therefore a simpler question as to why do films in India have a larger and are looked at it from a different plane of expression. Okay. Then the next question in 2015, standard, straightforward, not with specifically to a religion, but all religions combined. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided in the directive principles of state policy. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided in the directive principles of state policy. Alright, now this is a question simply asking you to analyze what are the challenges to implementing uniform civil code, a standard theoretical answer. In your introduction, perhaps we can write some contemporary developments. Now, 2015, again in the context of current affairs. Does the right to clean environment entail legal regulation on burning of crackers during Diwali? Discuss in light of Article 21 of the Constitution and the judgment of the Apex Court or the Supreme Court in this regard. This question is basically asking you that, see, Article 21 also gives you the right to a clean environment. No doubt, it absolutely does. And Article 21, because it gives you a right to a free environment, to a clean environment, to a healthy environment, in order to implement that right, is it justified to regulate the burning of crackers during Diwali? Because if you have the right to a clean environment, you also have the right to celebrate a festival as per your own requirements as a free citizen of this country, right? So, how are these two rights conflicting with each other? This is because of massive issues that were in the news in 2015, which eventually led to the Supreme Court banning firecrackers during Diwali and only allowing for green crackers which are made from sustainable products and in a legitimate manner. Okay, so this is the next question which was asked, right? Similarly, when we look at the next set of questions, this is directly from the preamble. We've covered this already, right? The question was, discuss each adjective attached to the preamble. Are they defendable in the present circumstances? I have covered this extensively, given you a structure about this, taught you the X and Y concept of means answer writing. So, are we sovereign? Are we socialist? Are we secular? Are we democratic? And are we a republic? Now, the question is attached to the word republic. It is not asking you to justify whether we are a republic or not, because we are a nominal republic. It is asking you to justify how are we a sovereign country, how are we a socialist country, how are we a secular country, and how are we a democratic country. I have given you enough of information on this when we had discussed the preamble. Then in 2016, what was held in the IR Coelho case? In this context, can you say that judicial review is of key importance amongst the basic features of the Constitution? So, two parts to it. First, what is IR Coelho? And second, why is basic judicial review important? And how and why and if it should be a part of basic structure or not? Simple question. You could have been able to answer this from yesterday. Then, 2017, the Puttuswamy judgment was delivered. Examine the scope of fundamental rights in the light of the latest judgment of the Supreme Court on the right to privacy. So, once the right to privacy has been declared, what happens after this declaration? Once the Supreme Court has declared that Article 21 is also going to include the right to privacy, what is this going to impact? What are the other legal changes, socio legal changes, rights driven changes that the country can witness just because right to privacy has now been made a constitutionally recognized fundamental right? Simple question, but this is after the judgment was released in 2017 itself. And this was so much in the news in 2017 that even if you didn't read the newspapers, you would still know of something called the right to privacy. Then in 2019, there was a question which said, what can France learn? What can France learn from India's approach or Indian constitution's approach to what is called secularism? Again, active and passive, welfarist and interventionist. That is it. You don't have to worry about what France has to particularly say about it, right? In 2019, there was a question very similar. In 2019, there was a question very, very similar. The Parliament's power to amend the Constitution is a limited power and it cannot be enlarged into an absolute power. In light of this statement, explain whether the Parliament under 368 can destroy the basic structure of the Constitution by expanding its amending power. We have done this question in absolute detail in yesterday's class. And if you notice carefully, this question is very similar to the first question that we had discussed on critically analyze the amending power of the Parliament of the Constitution. It's the same question but asked differently and very pinpointedly asking you that can the Parliament destroy basic structure? To which I told you when we discussed basic structure day before yesterday, the Parliament can't, because the basic structure doesn't exist in the Constitution. So if it doesn't exist in the Constitution, then that means you can't change what is not in the Constitution. And the only way you can probably do it properly through legal means is have a 13 bench or higher judges of the Supreme Court, or the Parliament can try to do it indirectly or through extra constitutional means. But directly, when something does not exist, you cannot really remove it from the Constitution. Okay? So, this is something which is important. This is something which is there, and these are the kind of questions that were asked in 2019. Okay. Now that we are absolutely clear with this, right? Now that we're absolutely clear with this, okay, it is therefore very important for you to understand what were the kind of questions that were asked this year in the mains exam. Okay, in the 2021 mains exam, in the 2021 mains exam, there were two questions that were asked. The first question was on constitutional morality. The first question was on constitutional morality, and the second question was comparing India and the US, on the basis of the right to equality. Now, people had an issue with both of these questions because these were derivative questions, right? So, the question, if I remember correctly, and I'll tell you exactly what the mains question was, and don't worry about it, I'll just show you the question. I'm uploading the question on the drive so that everybody can access it. See, constitutional morality, constitutional morality is rooted in the Constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. With the help of relevant judicial decisions. Okay. Lavanya, I'll always be giving you a master list of Supreme Court judgments. Don't worry about it. Okay. Now, if you look at the question itself, you'll understand what is it that we are referring to? If you just look at the question itself, right? See, it says constitutional morality comes from the constitution itself and is based on its essential facets. If you look closely, essential facets could also mean something called basic structure. Explain the doctrine of constitutional morality with the help of its relevant judicial decisions. Which means all that you have to answer are three things. First, what is the doctrine of constitutional morality? It's basically determining the morality in a country as per the values and the aspirations of the constitution. The word morality in the constitution, very specifically, is under Article 19 and under 25 under the reasonable restrictions of Article 19 and 25. Broadly, these two articles. 25 also by extension 26 and Article 19 clause 1 clause 2. Right? Broadly, this is where you will find the word morality. Okay. Now, you have to explain how it is rooted in the constitution itself. This is where it is. And how is it based on essential facets. So all you have to explain how Keswananda Bharti and Minerva Mills were the two cases which operated primarily on the principles of constitutional morality. That the makers of the constitution intended the constitution to be changed, but did not intend the constitution to be changed to such an extent, that you would change the very ethos, the very core of the constitution, which is why the doctrine of basic structure made a lot of sense. Okay? And then you can apply 19 and 25 related issues. So, for example, you would look at Sabrimala, you would look at, say, citizenship protests, and how these were largely questions of constitutional morality. LGBTQ reservation, these are all questions of constitutional morality. That Supreme Court upheld reservation eventually because equal protection of law is a constitutional principle and is therefore moral as per the constitution. Supreme Court declared the entry of women to Sabrimala temple is perfectly okay because the constitution does not permit you to discriminate on the basis of gender, even if it's about accessing a public place such as a temple. The Supreme Court has upheld the rights of transgenders and decriminalized homosexuality because Article 19, 21, and of course by extension 25 say that you cannot discriminate against people on the basis of their orientation. So these are a few examples that you could give. You barely had to write about 2 pages for it and it would be more than enough. Okay, so that's the kind of question you would get. Now, the next question which came from this particular topic was actually the question here, the 13th question. Analyze the distinguishing features of the right to equality in the constitutions of US and India. Now remember what we have discussed in our classes. We are talking about right to equality, which means we are going to also talk about rule of law. And for rule of law to exist, we will talk about procedure established by law, and we're going to talk about due process of law. After we've talked about both of this, then we will understand equality, equal protection of law, and equality before law. So we have to look at the distinguishing features. For example, US explicitly has due process of law and India doesn't. In US indirectly have notions of affirmative action, but India directly does, right? So that's the basic difference. Due process of law is explicit in the US, not in India. It is done through Supreme Court decisions. Equality before law is explicit in India, not in the US, and in the US it is also done by their respective decisions. And you have to just give some examples for it and your answer is ready. So this question seemed like a very tough question, but actually wasn't a tough question at all. You just had to break right to equality. You don't even need to know the technicalities of the US Constitution per se. You can answer that question from a larger and from a more symbolic angle, so to speak. Okay? Are we clear on this? All right. Now, so these were the two kind of questions that were asked. Now, with this, we have understood that as far as the mains is concerned, we have some key analysis points. We have some key analysis points. First, as far as the basic structure is concerned, we just need to know a broad summary of the timeline so that we understand what is going on. What we really need to know is the analysis, the impact, and the future of the basic structure doctrine. And we should also know a summary of developments with respect to fundamental rights versus directive principles of state policy. Okay, this is it. As far as our rights issues are concerned, they will always be asked from a current affairs context. And this current affairs context is going to be extremely obvious. Extremely obvious. The newspapers were going crazy about Section 66A. The triple talaq issue, the Shaira Bano issue is why the UPSC asked you about Uniform Civil Code. Right? So it'll always be extremely obvious. You can't go wrong with it. It's so in your face. Supreme Court banning firecrackers and so on and so forth. And as we had discussed, if the judgment has not come, then you can be asked whether a right is violating a law or not. If a judgment has been delivered, then you would be asked the impact of it, right? Whether a right is being violated by a law, by an action, by an order, or anything, right? And when we saw the most important fundamental rights that were being used in the mains were 14, 19, and 21, out of which 19 and 21 were actually being asked as real issues. 14 is the supportive article, right? And apart from that, directive principles, and the only question that has ever been asked are Uniform Civil Code, which is by extension also with Article 25, right? So this is more than enough. This is what we need to know, right? So now that we are clear with this, now that we understand exactly what we're going to be studying, so we're going to start with our first topic, and we're going to start with our discussion on the relationship between Articles 14, 19, and 21. And this relationship primarily has two cases. The AK Gopalan case, one of India's first preventive detention related cases, AK Gopalan case of 1950. This case basically said 14, 19, and 21 are separate and they should not be read together. They have to be read in silos. And this case was directly overruled by a 1978 case of Maneka Gandhi versus Union of India. Minka Gandhi versus Union of India of 1978, where the court basically said 14, 19, and 21 are correlated to each other and they work in cooperation. So, we are going to discuss this. We are going to primarily focus on the Menka Gandhi case, an extremely important case. We'll go through this. This is a story, this is a beautiful story. I will narrate the story to you, I will discuss the story with you. So, don't worry about it. Okay? I'll just need to have a glass of water. Just give me 2 minutes or so. We'll begin. Okay? Sorry. Yes. Let's start with the Menka Gandhi judgment. This judgment, innocent in its facts, innocent in its approach, innocent in its circumstances, prompted the court to get into certain issues, get into certain problems, which led the court to truly revolutionize the way we understand fundamental rights. Ladies and gentlemen, this is the story of Minka Gandhi, right? Let's forget about the worries of it. Let's forget about the politics of it. Let's understand what had happened, right? So, let's start with the Minka Gandhi case. We're going to discuss Menka Gandhi versus Union of India of 1978. So, who was Menka Gandhi? Why are we talking about her? Menka Gandhi was a journalist. She is a politician now, but she was a journalist. Okay. Now, Menka Gandhi was a journalist. In 1976, her passport was issued to her. She was issued an Indian passport, of course, by the Ministry of External Affairs through the Regional Passport Office, and the law under which you are entitled to a passport is the Passport Act of 1967. You would remember we had briefly referred to this in the CAA protests, in the Citizenship Amendment discussion. Okay. In a year, in 1977, the Regional Passport Office, the Regional Passport Office of New Delhi issued the order to her, okay, to surrender her passport. When she asked what the reasons were, she was informed that the reasons is in the interest of general public. Okay. This is why she was asked. Now, as a result, she filed a petition under Article 32, which means she went directly to the Supreme Court. She filed a petition under Article 32, which means she went directly to the Supreme Court, and she said, my rights 14, 19, and 21 are being violated. Okay? My rights 14, 19, and 21 have been violated. How? Because you are discriminating against me through the Passport Act without any reasonability, just because I am a journalist, just because I'm critical of the government. The law is discriminatory. You are treating me unfairly before a law, or you're treating unfairly and cancelling my passport. Second, I have the right to freedom of work, profession, and trade. And by restricting my travel, by not allowing me to have a passport, you're affecting my Article 19. And Article 21 also has something called personal liberty. It is my choice whether I want to live here or I want to go to another country. You cannot stop me from doing so. You cannot stop me from traveling abroad. It is a violation of my personal liberty. These were the primary grounds. These were the primary grounds on which Menka Gandhi went to the Supreme Court. The government, the Attorney General at that time, of course, was representing the government in the Supreme Court. The Attorney General broadly said, well, we have the right to suspend or ask you to surrender your passport because you were supposed to be present in court. You were supposed to be present because of an inquiry that was being conducted and you did not show up. And because you did not show up and there was an inquiry that was being conducted and you were supposed to be testifying before that commission of inquiry, unrelated to the passport matter, you were supposed to be testifying before that inquiry and you decided to not show up. And because you didn't show up before that commission of inquiry, we decided to surrender your passport because you were required to be present before an inquiry. Right? This was broadly how it went. Now let's understand what were some of the primary arguments that were made in detail. These are not important for your exam. This is to make you understand what really happened. So, what were the arguments by Menka Gandhi's lawyer, or what were the arguments primarily by Menka Gandhi? What were some of the basic things that Menka Gandhi and her lawyer said in court? So let's understand this. Okay? Very simple. Now, the first thing Menka Gandhi said is that, boss, my right to travel abroad, is a fundamental right and is a derivative of the right under personal liberty, and therefore Article 21 gives me an indirect fundamental right to travel abroad. Okay? And Article 21 definitely says, and if you remember Article 21, it says no person will be deprived of life and personal liberty except according to procedure established by law. Which means the only way you can restrict Article 21 is through procedure established by law. There has to be a defined procedure established by law. And the Passports Act that you are referring to does not give you any procedure for it. It does not mention a procedure through which you can stop me from going abroad. So you have not reasonably restricted my right, and I have an inherent right to travel abroad in the first place. That's the first argument Menka Gandhi and her lawyer made. Second, she said, if you have the right to surrender my passport, you also have the right to tell me and give me an opportunity to explain my side of the story. If you are wanting me to surrender my passport, if you're ordering me to surrender my passport, you just can't order like that. You have to first hear my side of the story. You did not give me an opportunity to be heard. And this opportunity to be heard is a larger legal principle called the principles of natural justice. And we'll come to what they are. One of the principles of natural justice is that you have the right to a free and a fair trial and the opportunity to be heard. And I'm not being given that opportunity. Without hearing my side of the story, you're taking an action against me. You want me to surrender my passport. You have ordered me to surrender my passport. At least hear my side of the story first. Don't just jump on it. That's the second primary argument that she made or her lawyer made before the court, right? And third, she said, no problem. Through procedure established by law, you can reasonably restrict my fundamental right, but this procedure must be fair and must also comply with the same principles of natural justice. Must comply with the same principles of natural justice. And remember the mind of the makers of the Constituent Assembly. Think of the members of the Constituent Assembly who drafted the very constitution which gives me the right to take you to court. And the mind of the makers of the constitution was very clear that 14, 19, and 21 must always be read together. They are interrelated rights. They form what is called the golden triangle, the holy trinity of the Constitution of India, which you have happily ignored. And this is something we will not be willing to let go. And if you are talking about Article 19, we know that Article 19 has restrictions under Article 19 Clause 2, and there are no such restrictions on grounds of me wanting to travel abroad. There is no such right. There is no such right says that you can't travel abroad. There is no reasonable restriction under Article 19 Clause 2 under which you can stop me from going abroad. Not at all. You are making it up. And by taking away my passport, by cancelling my passport, you are actually detaining me in my own country. The whole country is becoming a jail to me. And Article 22, very small extension, preventive detention rights are also being violated. There is no reason for you. We know preventive detention is to stop you from committing something wrong, right? To stop you from committing something wrong. That's a very important argument, an extremely important argument. Clear? And therefore, this Passports Act, which is allowing you to cancel my passport, is not a reasonable restriction. There is no procedure mentioned. You are violating Article 21. So therefore, this particular one provision of the Passports Act, I think the provision is not important at all. Section 10, Clause 3, Clause C, I think. That particular section of the Passports Act, it must be declared as unconstitutional. And we use a Latin word called ultra vires, which means violative of or outside the scope of the Constitution. So this section of the Passports Act is ultra vires of the Constitution. These were the massive arguments that were made by Menka Gandhi. And on the other side, you had Union of India represented by the Attorney General. None of this you have to remember as far as the mains exam is concerned. This is just to make you understand this better. Attorney General said, 1 second. Who said that you have a right to travel abroad? Article 19 Clause 1 says you have a freedom to travel anywhere in the country, reside anywhere in the country, settle anywhere in the country. So go reside, travel anywhere in the country. Who's stopping you? Nobody is stopping you from traveling and residing anywhere in the country. We are stopping you from traveling outside the country. So if you want to play maths with me, you want to play law with me, let me tell you what the law is. The law is extremely clear that under Article 19 Clause 1, the right to travel abroad is not mentioned anywhere at all. Not mentioned at all. You are deriving it on your own. Nowhere does the Constitution say Article 19 means the right to travel abroad. Okay. And second, you are questioning the Passports Act so much. You are misunderstanding the intention of the Passports Act. The Passport Act was not created to suppress the fundamental rights of the people to travel if you think there is a fundamental right. The Passport Act is not a restrictive law preventing brain drain or preventing people from traveling out of the country. The Passport Act has been created so that on cases of national security or public safety or national security, we can prevent somebody from going out of the country. Tomorrow, you're a journalist, you go out of the country, you start addressing the people of another country, you hold a public press conference, and you say some nasty things about the government, because of which the relationship between that country and India is compromised. Aren't you violating interstate relations? Isn't that a reasonable restriction under Article 19? Of course it is. Of course it is. Tomorrow, if you go there and you say something, you disclose something, you release certain facts, you're a journalist, you have access to privileged information, you say something out there, and what if the security apparatus of the country is at stake? It has been exposed. What if something happens to you? Aren't we responsible? You are our citizen. Then you can't conveniently say this is fundamental right, that is not fundamental right. You can't have your cake and you can't eat it too. So don't misread, don't misjudge the interpretation of what is called the Passports Act. Don't do that. And the reason we asked you to surrender your passport, the reason we ordered you to surrender that passport is because you faulted. The government was conducting a commission of inquiry. This is basically an inquiry on a specific issue. This issue had nothing to do with the passport. You were supposed to come before an inquiry. You did not. You were absent. You were asked to come before that inquiry. You did not. And as a punishment for you not appearing before a government inquiry, we stopped you from traveling abroad. If we require you to be present before an inquiry, you better be present before an inquiry. If not, then we have the right to cancel your passport. We are the ones issuing you your right to passport. We are the ones who are able to cancel it also. And boss, dear Supreme Court, the Ak Gopalan case, the Supreme Court has very clearly said, the Supreme Court in the Ak Gopalan case has very clearly said that, boss, you cannot correlate principles of natural justice with respect to Article 21. You cannot correlate this. Please don't bother. You cannot correlate this. It is a clearly laid down previous Supreme Court judgment in Ak Gopalan. Ak Gopalan was basically a preventive detention case. Okay. And boss, what is these principles of natural justice that you're talking about? These very principles of natural justice are extremely vague. They're extremely ambiguous. Right to be heard, right to a free and a fair trial, right to not be forced to be a witness against us. These are the broad principles that are derived. None of these are mentioned in the Constitution. None of these are mentioned. Right to be heard is not mentioned anywhere. Why are you making up derivations of the Constitution? Why are you making out derivations to the Constitution which don't exist? The law has been applied properly. Okay? You are saying 14, 19 and 21 are correlated, but they are not. 14, 19, 21 are not correlated. For the passport law to be declared, for that section in the passport law to be declared unconstitutional, it must specifically violate 14, 19, and 21. This procedure established by law, all that it says is your 21 can be restricted to procedure established by law. It does not say the procedure established by law has to be reasonable or not. As long as there is a procedure which is established through a legal process, that procedure is right. You and I cannot question it. If you could question every procedure written down in every law, then what is the point of having law? Then we will spend half our lives in this very Supreme Court arguing about procedure all our lives. Is that what we want? You want to question the procedure behind the law. You want to question the intention. Don't forget, the makers of the Constitution purposely said due process of law is not going to be a part of the Indian Constitution explicitly. This is the doing of the Honorable Supreme Court. They had considerable amount of debate and they said we will have procedure established by law in the Constitution, not due process of law. So if you're quoting the makers of the Constitution, you're saying, oh my God, the Constitution is so great, it's so amazing. The makers of the Constitution wanted to deal with 14, 19 and 21 together, then you must also know they never wanted you to question the integrity of the law, which is what you are trying to do under the garb of due process of law. What you are basically trying to do is under the garb of due process of law. And that is why procedure established by law was a part of the Indian Constitution and due process of law was not. The courts heard both sides of the story and the court said, fine, these are going to be the primary issues. These are going to be the primary issues in the Minka Gandhi case. And we're going to be very clear about our primary issues. First, when we say fundamental rights are applicable within the territory of India, what do we mean by the territory of India? What is meant by the territory of India? Are they absolute or conditional? Are fundamental rights supposed to be absolute or conditional? And to what extent is the territory of India valid? फर्स्ट क्वेश्चन, सुप्रीम कोर्ट ने कहा ठीक है बहुत बोल लिया, अब इसको हम सिंप्लीफाई करते हैं. सेकंड, डू यू हैव द राइट टू ट्रैवल अब्रॉड? डू यू हैव द राइट टू ट्रैवल अब्रॉड अंडर आर्टिकल 21? थर्ड, ये 14, 19 और 21 का रिलेशन क्या है, कनेक्शन क्या है? ठीक है. फोर्थ, प्रोसीजर इस्टेब्लिश्ड बाय लॉ का स्कोप क्या है? Does it also include due process of law or not? Or is it just procedure established by law? Or is it just procedure established by law? And as far as this passport right is concerned, this specific section completely irrelevant for you. Section 10 clause 3 clause C of the Passports Act, is that constitutional or not? Is that constitutional or not? And this order that has been given by the regional passport office ordering you to surrender your passport is that violating the principles of natural justice? And what is the scope of the principles of natural justice? ठीक है, clear? Seven judges. Seven judges. Seven judges sat down. And through these seven judges, including Justice Bhagwati, who's known as the father of PIL in India, the recognition and the acceptance of PIL in India, and Justice Chandrachud, who's the father of the current sitting Chief Justice, current sitting Judge of the Supreme Court, Chandrachud, were also a part of this bench. Seven judges sat down and they discussed these matters. Right? And it is through this case that we got clarity on some of the most fundamental issues that were before a court of law. Okay, fundamental clarity. First things first. Let's look at the basic principles. Let's look at what the judgment was. What are our important learnings from the judgment? Okay? See, before the enactment of the Passports Act, there was no law which regulated the passports and which regulated any person's ability to travel abroad or move abroad. There was no law. The Passports Act is the first and the only law in the country which is basically regulating a person's right to travel abroad. And the government was absolutely discretionary in deciding whose passport they can ask to be surrendered and whose passport they can ask not to be surrendered. Right? And this discretionary power of the government is dangerous. Is absolutely dangerous. And while you made a law through which you can surrender the passport, but you did not make a law with respect to the rights of the person whose passport you have surrendered. You did not make a law with the detailed procedure of the person's passport that you have surrendered. And when you don't make such a detailed law, your procedure is incompetent and therefore it violates Article 21. And not only this, you are saying that in the interest of the sovereignty of the state, in the integrity of the nation, its friendly relations with neighbors, its security, you can do so, no doubt. But boss, whenever you are asking a person to surrender their passport, because if it is violating security or sovereignty or the interests of the state or the integrity or the public safety, you have to very clearly record and document and tell the person, these are the reasons under which we are going to be stopping your passport. The government did not give any substantial reason whatsoever. None at all. The government said this has been done in the interest of the public. The interest of the public or the general interest of the public is not mentioned anywhere. Is not mentioned anywhere in the Constitution. Is not mentioned in any law. You are making up a reason and you're telling the people about this. And therefore, this entire process is faulty. So the Supreme Court very clearly said in one line, as important as it is for UPSC, that your passport surrender was unconstitutional. Was unconstitutional. बस इतना बहुत है, बाकी सब तो कहानी है. Then we come to the bigger questions, the questions that you and I have to be concerned about, because this is not going to be asked in UPSC. The Supreme Court very clearly said that any of the fundamental rights which are contained in Part 3, they are not mutually exclusive. They are correlative to each other. They will always be correlative to each other. Always be correlative. आप ये नहीं कह सकते कि 14, 19, 21 आपस में जोड़ना मत. Of course, if a law is treating you unequally, it may affect your freedom of movement, your freedom of profession, and if it is affecting your freedom of profession, it is also going to affect your personal liberty, your life. How can you treat these rights exclusively? How can you treat these rights as independent for each other? Right? Whatever you want to do, whatever restriction you want to do, you must always do this in a very, very fair and a reasonable manner. ठीक है. Now, the Supreme Court also very clearly said, Mana, Article 21 says procedure established by law. But it also says, and what it means is, that the procedure must be rational, must not be arbitrary, must be fair. And if it is supposed to be rational, non-arbitrary and fair, that means you are going to be questioning due process of law. So, in Minka Gandhi, the Supreme Court said, due process of law in the Indian context will include, procedure established by law will include due process of law. हमने नहीं लिखा तो क्या हुआ, include तो करेंगे और 100% करेंगे. ठीक है. And this entire process is a clear violation of the principles of natural justice. Is a clear violation of principles of natural justice. ठीक है. Understood? Now, principles of natural justice basically are two Latin phrases. You don't have to do them as Latin phrases. They're actually three, but the two very important. So let's understand what they are. The first is, nobody should be made a judge in their own case. Nobody should be forced. Basically, you should have the right to a free and a fair trial. And the second is, you cannot be forced to say something against yourself in your own case. There are two principles of natural justice. One, of course, is that you have the right to a free and a fair trial. And second, you can't be a judge in your own case, which means you cannot be forced to have a bias against yourself in your own case. This second part is often used as self-incrimination protections, and free and a fair trial also includes the right to be heard, which was being violated in the Menka Gandhi case. Principles of natural justice are perfectly valid, are always going to be an essential component of India. All right? Understood? And Menka Gandhi very clearly in this, the Supreme Court said, you don't have the right to travel abroad unconditionally. Understood this? This can be restricted through law, but the law must always be fair. And as I said, this also overruled the Ak Gopalan case and said 14, 19, and 21. 14, 19, and 21 are correlative. Okay? Understood this? And I understand that fundamental rights can only be enforceable in India. That doesn't mean that an Indian in the US does not have Indian fundamental rights. You can't do anything about it in the US. I understand that. But you still have those rights. Okay. These are some things that the judgment taught us. And this is how the judgment is where some very important principles came about. Today, when we say right to privacy violates 19 and 21 and 14, or privacy is a part of 14, 19, and 21, it's thanks to Maneka Gandhi. LGBTQ has relationships with all the three rights. It's because of Menka Gandhi's case. Agar ye nahi hota, then you would have not been able to look at multiple right violations on a simple single issue. खुद ही सोचिए. Today you have the right to clean air, we have the right to free legal aid, we have the right to clean drinking water, we have the right to food. All of these interpretations have been possible out of Article 21 because of Maneka Gandhi, because of this particular case. Understood this? Sure? Yes, we do. Wherever we do. आया समझ में कि कहाँ पासपोर्ट के इशू से कहाँ हम पहुंच गए. सुप्रीम कोर्ट बाल की खाल निकाल लेता है. ओके, क्लियर? तो हमारा पहला टॉपिक और दूसरा टॉपिक कवर हो गया. Now you can take a 5-minute break. We'll start with Article 19 in one go. Yes. Who said right to health was parole? Yeah. You restrict your travel abroad under reasonable restrictions. The law is fair. Yeah. AK Gopalan said 14, 19, and 21 can't be read together. Menka Gandhi said no, it should be read together. Yes, Kante. 2 and 6 are how? No, they are not. How are they opposite? If they were mutually exclusive, that means 14, 19, and 21 would have been separate. They're not mutually exclusive, which is why they have to be read together and they can be read together. How are they mutually exclusive? Dipesh Kumar ji. Yeah, not finally surrendered. Passport had to be given back to her. Of course, reasonable restriction is सब सही है. Fundamental rights are not absolute. Okay? Right. Take a 5-minute break. Take a 5-minute break. Take a 5-minute break. Yes, Vignesh. Thank you, Vaibhav. Chali. So we start with Article 19. I've already covered basic structure. These are the notes for basic structure. Okay. Let's start. Now, through Article 19, we will understand certain very important issues that are obviously present before us, that have already been a part of us. So, if you ever get an essay on freedom of speech, freedom of information, all of those things, it's extremely important for you to understand if you had to write a quote on it, right? It is from the same Menka Gandhi judgment. It is from the same Menka Gandhi judgment that we will refer to a certain quote here. This quote has been given by none other than Justice Bhagwati in the Minka Gandhi case. It's a very simple case. It's a very simple quote. It's a very simple quote that says, देखिए, democracy is based on free and open discussion. If you're not able to discuss anything and everything, and if you're not able to question anything and everything, then you are not in a democracy. And this is also true, particularly for the times that we live in, where it is often considered as non national or unpatriotic to question a few things in the country. That's not how democracy works. You have the right to question anything and everything as long as you do it in the right manner, as long as you do it in the competent manner, as long as you do it in a manner which is reasonable, which is intelligent, which is thought provoking. Right? ठीक है. So, it is a matter of absolute privilege for us to be a part of democracy, for us to be a part of a discussion. And the only way you can make the government better is by questioning things around us. If a simple kindergarten meaning is that the government is of the people and by the people, then it is only natural that people should be entitled to participate in the process of democracy. And for that, a general discussion on public matters is absolutely essential. Now, this quote was in the context of the Minka Gandhi case because we have the right to discuss the grounds under which her passport was surrendered. Right? Now, Article 19, as we know, originally had 7 rights. One of them was with respect to property, and that was removed through the 44th Amendment. So, Article 31 and 19, Clause 1, Clause F. This is all under Article 19, Clause 1. This is 19, Clause 1, Clause A, B, C, D, E, and G. F was with respect to property, and that has been removed. So we have the freedom of speech and expression. The basic difference is speech is verbal, expression is everything else. Speech is verbal and expression is everything else. This means you have the right to express your opinion in a written form, through films, nowadays through OTT platforms, through paintings, through cartoons, and so on and so forth. To assemble peaceably without arms also means the right to protest, the right to strike. Do you actually have one? And when you combine both of this, you understand whether we are going to have hate speech as an ingredient of freedom of speech and expression, and because you're writing or you're presenting an opinion, what about the rights of the press? This right to form associations or unions, which through the 97th constitutional amendment also includes cooperative societies, and that part is not particularly relevant in terms of issues. But the right to form associations or unions also assists in understanding our rights to protest versus the right to strike. And then, of course, you have the right to freely move throughout the country, to settle anywhere you want to, and practice any business, trade, or profession that you want to. Your reasonable restrictions are from Articles 19, Clause 2 to Articles 19, Clause 6, right? So 19.2, 19.3, 19.4, 19.5, and then 19.6. As far as the mains exam is concerned, it is the first three fundamental rights, Articles 19, Clause 1A, B, and C, which become extremely important, and questions are usually asked from here itself, right? So, for example, which was in the news, Section 66A is primarily declared unconstitutional on grounds of Article 19, Clause 1, Clause A, because the government was using the powers of Section 66A to curb what is called dissent, disagreement with the government, right? And if you want to have an opinion, you want to write an opinion, you want to express an opinion, this opinion can be an opinion about the government. And because fundamental rights are primarily available against the government, it basically also means that we have the right to have information of the government, to form an opinion on the government, which is why the Supreme Court later said that Article 19 in an implied form will also include the right to receive and disseminate information. And that is why the right to information is an implied fundamental right, under Article 19. Okay. And it's not just us. This freedom of expression, this freedom of information is internationally celebrated. When you look at UN documents such as UDHR, the Universal Declaration for Human Rights, or the European Convention on Human Rights, or the International Covenant on Civil and Political Rights, ICCPR, or ECHR, they all guarantee the freedom of speech and information. And as far as our mains exam is concerned, we will focus on the first three rights and the issues arising out of the first three rights. Okay. Issues relating to these rights and the issues arising out of these three specific fundamental rights. Okay? Understood? Now, we understand that broadly the restrictions on these rights are fairly clearly outlined, right? 19.2, 19.3, and so on and so forth. Sovereignty and integrity, friendly relations, public order, security of the state, decency, morality, defamation, contempt of court, and incitement to an offense. It is also through these restrictions that we understand. Like, for example, contempt of court means contempt of court is regulated through a law called the Contempt of Court Act of 1971. which says there are two kinds of contempt: civil contempt and criminal contempt. You will do this in judiciary related issues, but civil contempt and criminal contempt. Civil contempt is if you are not following a court order, so you will have to pay a fine for it. Criminal contempt is that if you're saying something which is violating the reputation of the court or the judge, then you can go to jail for it. Most recently, the Prashant Bhushan case was why contempt of court was so heavily in the news over the last 2 years, right? And a need and a debate was that contempt of court, is this fundamentally okay? Because on one hand, you are saying you have the freedom of speech and expression. So I am allowed to have an opinion on the Supreme Court of the country. If I'm allowed to have an opinion on the Supreme Court of the country, then in a scenario, you cannot stop me from having a bad opinion on the Supreme Court of the country, right? So that is why sometimes contempt of court can be misused by the courts to punish people who say anything which tarnishes the reputation of the court, which tarnishes the integrity of the court, right? So you have a lot of these reasonable restrictions, a lot of these clauses to Article 19 clause 1, which is now in Articles 19 clause 2 to Articles 19 clause 3. Okay. Now, we understand that if in the mains exam they ask you, and they've asked you before, what is freedom of speech and expression, what is its importance, this means we are going to obviously be looking at some basic freedoms. Why are they important? First, in a democracy, the freedom of speech and expression is one of the prime liberties guaranteed to its citizens. If you don't give the citizens these kind of rights, then you are fundamentally compromising the very rights of our citizens. Okay? Second, it makes sure that we are able to keep our government, our political leaders accountable by constantly telling the people around us and them what we think of them. Third, it is only through this that you're able to bring to the fore the issues and the objections and the repercussions to minorities in the country. Otherwise, how else will you make sure that the rights of minorities are heard? And fourth, this is the creative license, this is the creative green signal that is needed to people who work in the creative fields. How else will academic writings, cartoonists, poets, painters, satirists, theatre artists, visual arts, and most recently stand-up comedies, how are they ever going to function? Because these are very opinion-based. An editorial that you write in the newspaper, a stand-up comedy gig that you do, a play that you enact in a theatre, a movie that you make, a series that you make, these are all forms of expression. Sometimes they can raise some fundamental questions on society in a funny way, in a serious way, in a thought-provoking way. But unless you don't give them these kind of protections, they will never be able to exist in the first place. And this is why freedom of speech and expression is incredibly important in the domain of the country, is incredibly important in the length and breadth and the understanding of the country. Okay? And let's now understand what is the basic difference. We're going to first talk about speech and then we're going to talk about expression. So when we talk about speech, and this is extremely important, what are the basic ingredients of the freedom of speech? First is the freedom of press. अगर मुझे बोलने की आज़ादी है तो मुझे रिपोर्ट करने की आज़ादी है, मुझे लोगों को इन्फॉर्म करने की आज़ादी है. Now, very interestingly, and I'm going to get into a lot of this, I'm going to get into a lot of detail here. See, you must understand, India is one of those few countries in the world where journalists don't enjoy any special rights. The rights of a journalist are exactly the same rights as any other citizen in the country. But you must understand that a journalist is not like any other citizen in the country. The journalist is performing some functions, some essential functions that makes the journalist a more heightened individual. You would understand this more clearly in the context of the Pegasus issue, right? Now, all of you know that Pegasus is a spying software manufactured by an Israeli defense firm, and the government of Israel has authorized this Israeli company to only sell Pegasus to the governments, to only and only governments, which means this Israeli defense company cannot sell Pegasus to non-state actors, to private companies, to other outfits. It can only sell Pegasus to the governments of other countries. So now what happened was that an international collaboration of journalists started investigating the matter, and then there were several documents that came to light wherein it was proven, or it alleged, or it mentioned that governments of a lot of countries across the world were using Pegasus software to maybe illegally spying on its citizens. Of course, India was also on that list. And what was very surprising to note were the kind of names that came out as far as this Indian Pegasus issue was leaked. No doubt, you had judges, you had lawyers, you had social activists, you had NGO workers, politicians, bureaucrats, and even members of the same political party as the government whose phones were being surveyed. What is extremely dangerous about Pegasus is that Pegasus does not require any physical contact with the mobile device. It can be uploaded to the mobile device electronically, wirelessly, sometimes by maybe just clicking a link. You don't have to necessarily necessarily plug a wire into a phone for Pegasus to be downloaded on it. When all of this broke out, there were of course questions, very, very severe and very, very sincere questions on the legitimacy of the government using a spying software to spy on its citizens. A gentleman called Manohar Lal Sharma, who's done a lot of other PILs also, filed a petition in the Supreme Court. The case is currently going on. As an immediate relief, the Supreme Court has appointed a committee to look into whether the government has been using Pegasus in an unauthorized manner. But you must understand, this Pegasus issue, no doubt it affects privacy, your personal privacy and all that, but it has a significant impact on the freedom of the press also. Because if a journalist's phone has been spied upon, has been tapped by the government, it is violating the integrity of journalism. See, how does this work? See, a journalist has a moral code. The moral code is to keep the identity of the source of the journalist extremely secret, to protect the identity of the informer at all costs, so that the journalist is able to get accurate, correct, and impeccable information, and there is no threat to the life of the person who is informing the journalist. You can call it a form of whistleblowing if you may. You're whistleblowing without really, telling the people that you are the one whistleblowing. You're using the media to tell the people about wrongdoing, and this is mostly done in the case of the government. So if you are a journalist and you know that your phone is being spied upon, there are two things that are going to happen. One, there's going to be a threat to your informer because the identity of the informer is now disclosed. And two, it'll start compelling you not to take up stories that go against the government. It will violate the integrity through which you practice the most honorable profession of journalism. And that is the freedom of the press. Now, very interestingly, in India, nowhere in the constitution is freedom of the press, fundamental rights of journalists, none of this is mentioned. The journalist enjoys exactly the same amount of rights, as any other citizen. There are no additional protections given to journalists in India, which is contradictory, which is ironical to the fact that India considers media as its fourth pillar of democracy. India considers media as its fourth pillar of democracy. In fact, in the Constituent Assembly debates, one of the members, Damodar Seth, had very clearly argued that we should give explicit rights to the press. And that never happened. Okay, that never happened. It was decided that you don't need it. It's okay. The rights that we're giving is more than enough. And I'm going to get into a deeper analysis of the freedom of the press and the evolution of it. We're going to look at the Lomesh Thapar case, Indian Express, Sakal Newspapers. We're going to look at all of these. So don't worry about it. The Bennett Coleman case, we'll get into it. So don't worry about it. So that's the first part. The second case is on the right to silence. The second issue, the second element of it is, अगर मुझे बोलने की आज़ादी है तो मुझे चुप रहने की भी आज़ादी है. आप मुझे कुछ फोर्स नहीं कर सकते. Which is also similar and it also is complementing the right against self-incrimination. But अगर मुझे नहीं opinion देना है तो मुझे नहीं देना है. This also makes a lot of sense given how notorious the media today has become, where they force people to present something before the media. That is also wrong. But interestingly, the Supreme Court in a case which is the Bijoy, Emmanuel and Kerala versus Kerala case, this case has nothing to do with the media. This case belongs to a bunch of students at a school in Kerala where the national anthem was being played. And the students, though stood up, they did not sing the national anthem. Now it is compulsory for you to stand up when the national anthem plays because we have a law for it called the Prevention of Insults to the National Honours Act of 1971. Under this, you have to compulsorily stand if you can. If you have a physical condition or if you're incapable to stand, it's fine. But if you can stand, you must stand for the national anthem. These children were standing, but they were not singing. So the school authorities dismissed them from school. They went to the court. Supreme Court said, boss, were they standing or not? Yes, they were standing. End of discussion. Whether they want to sing the national anthem or not sing the national anthem, that has nothing to do with you. They have the right to remain silent. You said you have to respect the national anthem by standing up for it. They were standing up for it. Whether they sing it or not is none of your concern. It's something you don't have to get into. Right? So that is a very interesting observation given by the Supreme Court. Okay? If you also have the freedom of the press, you also have the freedom to report and broadcast. We're going to come to this. We're going to look at it from the Indian Express case, the Bennett Coleman case, and so on and so forth. And of course, you have the right to be informed, which is where right to information becomes an integral part. And not only do you have the right to be informed, you have the right to be informed about the people in government. So in a very, very important case, Union of India versus ADR, the court very clearly held that voters have the right to know about their candidates. In electoral reforms, we will cover this in detail. That is why when nominations are filed before an election, the financial, criminal and educational requirements, educational qualification. There are no requirements as far as education is concerned. The financial, criminal, and educational details of the candidates must be compulsorily submitted, and they are made publicly available to the people of the country. You would have heard of several websites such as Know Your Neta or Know Your MP, so that you can get information about your candidates. So these are some very interesting ramifications, some very interesting derivations of the freedom of speech and expression. Now let's look at some of the cases, and through the cases we'll understand what is it that we are talking about, right? Of course, we've covered Menka Gandhi. I'm going to look at Ramesh Thapar, Sakal Papers, Bennett Coleman, and Indian Express. These are cases which largely deal with the freedom of the press. Okay, these are cases that largely deal with the freedom of the press. I am repeatedly telling you as clearly as possible that I will discuss the facts of the case with you. I will tell you what the facts are. But the facts of these cases, what happened in these cases, it's not important. All you need to know is what the Supreme Court said as far as these cases were concerned. Okay? So, let's very clearly and let's very simply understand what is this that we are referring to, what are the cases. So, let's start with Ramesh Thapar. Very interesting case and extremely important as far as the freedom of the press and journalism is concerned. Now, let's start. It's a beautiful story. Don't worry about it. Beautiful story. Okay. I'll take you back through history. This is the first ever case within the first ever year of the Constitution coming into force. If you remember, we discussed that the first constitutional amendment, which was passed by the Constituent Assembly, which became the interim parliament, was passed by the very same people who inserted the fundamental rights. And the first constitutional amendment is the one which actually restricts a lot of your fundamental rights. In fact, restrictions to Article 19 were actually inserted. भाई गुड मॉर्निंग भाई वो 1 मिनट के लिए ना मतलब 1 सेकंड के लिए वोल्टेज फ्लक्चुएट हुई थी तो लाइट वापस आ गई है 1 सेकंड के अंदर बस एक बार कमेंट बॉक्स में लिख दो दैट वील बी बैक इन 5 मिनट्स है ना हाँ हाँ मतलब लाइट आ गई है वो 1 सेकंड के लिए लाइट गई थी बस Okay. Sorry. Mic is okay. We just had a small voltage fluctuation. Anyways, let's continue. As I was saying that the journey of press freedom in India starts from the Romesh Thapar case, and let's understand what the case was. It's a very interesting case, a beautiful case. Just sit back and listen to the case. I'll tell you what it is. It's a story. Listen to the story, understand what happened. I will repeat this again. The facts of the case are not important. All you need to know is what the court said about it, and we're going to come to that, don't worry. But let's broadly look at what the facts of the case are, and let's figure out how we're going to solve the facts of the case. All right? So let's understand this. So, Romesh Thapar, this person that we are talking about, Romesh Thapar, this person that we are talking about, right, who we are referring to, was the editor, printer, and the publisher, okay, of a journal which was published in Bombay. This was a journal in English, and this journal used to be called Crossroads. Okay, this journal used to be called the Crossroads. Extraordinary journal, very well written. Now, the state of Madras, because in 1950 we did not have Tamil Nadu, we had Madras. In 1950, the state of Madras had a law, a very specific law. The law was called the Madras Maintenance of Public Order Act. The Madras Maintenance of Public Order Act. And under this law, under the Madras Maintenance of Public Order Act, the Madras government did not allow Romesh Thapar's journal to be circulated, to be distributed in the state of Madras. This, according to Romesh Thapar, was of course a violation of Article 19, because he said, I have the right to freedom of speech and expression throughout the country, and if you're not allowing my journal to be distributed in your state, you are causing what is called a violation of Article 19. The Supreme Court agreed with Romesh Thapar and said that, boss, the powers that were given to the Madras government under the Madras Maintenance of Public Order Act, these powers are unconstitutional. The Supreme Court struck down those provisions and said, no, you have the right to distribute your journal wherever and however you want to, and that is okay. Understood? And again, Madras government was saying it is on grounds of public safety. What if you are trying to communalize, or what if you're trying to spread hatred? We're not going to let that happen. So that is what. Which is why the Supreme Court, for the first time in 1950 itself, said, you know what? You have the freedom of speech and you have the freedom of expression, and that gives you the right, the freedom of circulation. That gives you the freedom of circulation. Your publications can be circulated all across the country, and therefore it is the foundational freedom to everything else that we know. And it was a very interesting case, the Sakal Newspapers case. Understood this? Are we okay with this? Yes? Alright. This was the Romesh Thapar case. Now, from the Romesh Thapar's case, in the next 10 to 12 years, we move to the Sakal Newspapers case. Now, as you can think, Sakal sounds like a Marathi word, and it is. Sakal sounds like a Marathi word, and it is. So let's understand what this case was. So Sakal Newspapers were basically a private company which publishes newspapers, right? A private newspaper publishing company. And Sakal Newspapers, and the company that used to print these Sakal newspapers were basically Marathi newspapers. They were printed in the Marathi language. Okay. And this paper used to consist of 6 pages or 6 or 7 pages through the year. Okay. And the newspaper had allocated about 40% of its space 40% of the total number of pages were for advertisements, because that is how newspapers generate revenue, right? Now, in 1952, about 10 years before the case got finally decided, in 1952, right, the government had appointed something called the Press Commission. This is an outcome of the Madras case. The government was upset, so they appointed something called the Press Commission. The Press Commission had given certain recommendations, and on the basis of that recommendations, a law was passed in 1956 called the Newspapers Act of 1956. Now, this was a very, very complicated law. This was a very, very weird law, for the lack of a better word. According to that, the newspaper company could only charge a certain amount for the newspaper based on the number of pages that they are publishing, based on the number of pages that they were publishing. And this Newspaper Act also very clearly established that you can give advertisements on X number of pages and you can't give advertisements on X number of pages. The areas in the newspaper where you could give advertisements, that was to be clearly defined as far as this Newspapers Act of 1956 was considered, right? The number of supplements, the magazines that you would give with your newspaper, they would all be heavily regulated. Okay. Of course, the newspaper company, Sakal Newspapers, challenged this and said, boss, nothing doing. You can't tell us how to price our newspaper, and you also can't tell us very clearly, you also can't tell us where and where not can we give advertisements in our newspaper. The Supreme Court heard the matter, of course, and the Supreme Court said, boss, very clearly, you have the freedom of speech and expression. The government has no business getting into how good or bad your speech or expression is, how effective your speech and expression is. The government cannot get into these technical details. The government cannot regulate the newspapers as heavily as it should. You have the right to disseminate information, circulate information, even if that information includes information about advertisements. And that is again a very important development in the field of press rights or journalistic rights. Okay? And then in 1973 and 86, two related cases, the Bennett-Coleman versus Union of India, which is the company which owns Times of India, and the Indian Express newspapers, Bombay Limited versus Union of India in 1986. Here also, there were some challenges made to newspaper laws, which were restricting the price and the circulation, and that was also challenged. And the Supreme Court declared that you cannot restrict the rights of the newspapers to do what they want to, as far as their newspaper is intact and has integrity. So this restriction under 19 Clause 2 was not valid, and the Supreme Court said that even a corporation has the freedom of speech and expression. See, Supreme Court, otherwise the government would have said, people have the freedom to speech and expression, journalists have it, citizens have it, corporations don't have it. You're a corporation. Fundamental rights are for citizens, not for corporations. The Supreme Court said no. Corporations also. You cannot violate the right of corporations. This is not a right available against corporations. This is a right of media organizations. Right? So this was the case. And of course, in the landmark Menka Gandhi judgment, the Supreme Court very clearly ruled that freedom of speech was not limited by geographical boundaries and therefore could be extended in both India and abroad. And these are your landmark judgments, right? Now, this has further been extended. We'll look at a couple of these. These have further been extended because today times have changed. In 1997, this is the pre-Manohar Lal case. The Supreme Court had said that illegal wiretapping is not permitted. The government, under the Telegraph Act, could look into conversations of people
In Union of India versus Association of Democratic Reforms in 2002, the government said that, boss, any information which is one-sided shall not be permitted, and we have to make sure that people are able to know everything that they can about the people and the instruments in democracy. You would remember this director of Rang De Basanti in Rakesh Om Prakash Mehra and Government of Delhi in 2013. The Supreme Court says not only do you have a freedom of speech, you also have the freedom after that speech has been given, right? In Shreya Singhal versus Union of India, the Supreme Court struck down Section 66A, which gives the powers to the government to suppress any dissent using an online platform. The original intent of the act was to stop communal hate, but the government started misusing this, and therefore Shreya Singhal had filed a PIL. Okay, this issue had become extremely unbearable when two girls in Bombay were arrested when they made a Facebook post criticizing why the city of Bombay was shut because Bal Thackeray had died. And most recently in 2020, the Supreme Court has very clearly ruled out that the government cannot unreasonably stop your access to the internet. This does not mean you have a right to internet. It just simply means the government cannot stop your access to the internet. The government cannot stop you from accessing the internet. The government cannot stop you unreasonably. This comes in the context of internet shutdowns, because today internet is a medium of information. Internet is a medium of discussions. Clear on this? Understood this? Yes? Pakka? And this is how it's largely done. This is what we should be doing. And these are the basic tenets and the facets of it. Okay? So these are your broad dimensions to press rights. From here, we will of course move to protest and sedition and so on and so forth. We'll cover the remainder tomorrow. This is more than enough. Your homework is, please read these slides and come to class. We will discuss farm protests, Lakhimpur Kheri, the Haridwar hate speech issue. We'll discuss the right to protest, the right to strike. We will also then get into other forms of other fundamental rights as well. Okay, so that's it for today. This is more than enough. I'll see you tomorrow. गुड मॉर्निंग भाई, हो गया है क्लास?